everyone, welcome back to Employment with Amy, weekly HR and employment law update. Hope you all had a really good week. Let's get started as always with the update of the Employment Rights Bill, of which nothing has actually changed in the last week. So just as I said last week, the bill passed its second reading in the House of Lords and will now move on to committee stage on April 29th. So we're still waiting for that. In terms of upcoming employment law changes, we've had the most significant ones within the last week, 1st of April and 6th of April, where we've had national minimum wage and living wage going up, statutory pay going up, national insurance contributions changes, and the Neonatal Care Leave and Pay Act coming in. I'll stop going on about the Neonatal Care Leave and Pay Act now that it's in, but if you haven't got your written policy, you can get one from my website. The link is in the description below. But for any further upcoming changes to employment law, all is pretty quiet right now. Still awaiting any updates from the Employment Rights Bill, of which the next update for us to hear will be on the 29th of April, as we've already discussed. So we're going to move on to tribunal news, the top 3 cases within the last week. First of all, we got a case involving the Tata conglomerate, the TSC part of Tata Consultancy Services. They're facing serious allegations in a UK employment tribunal. 3 former employees claim that the company unfairly targeted older, non-Indian nationals for redundancy during the 2023 restructuring. The lead claimant, Steve Beer, argues that the process was intentionally biased, using a pre-decided tick box system to cut higher cost, less compliant staff. Beer also accuses TSC of a bait and switch tactic, using local staff to win contracts, then replacing them with Indian workers to cut costs. Similar allegations have emerged in the US, where 22 workers have filed claims. TSC denies all accusations. The tribunal continues as 2 more claimants prepare to testify. Stay tuned and I will keep you up to date on this developing story. The next case concerns allegations of bribery. If you don't know, the Bribery Act 2010 is a UK law that sets out criminal offences for bribing another person, being bribed, bribing foreign public officials, and failing to prevent bribery by association persons. It applies to individuals and companies both in the UK and abroad and aims to promote transparency and integrity in business practices. So this case involves Hinkley Point, where a bribery scandal has rocked the nuclear power plant project. The Employment Tribunal heard that Ashley Daniels, a senior manager at the site, accepted lavish gifts, including an £11,000 quad bike and £2,000 boxing tickets from a subcontractor, Notice Heavy Lift Solutions, in exchange for directing work their way. The case came to light during an unfair dismissal claim by engineer Garrett Nesbitt, who admitted involvement in the scheme and called Daniel a greedy little toad. Although Nisbet won his unfair dismissal claim on procedural grounds, the judge ruled that he was complicit in bribery and he received no compensation, so that was a waste of time. ADF, which owns Hinkley Point C, confirmed that Daniels is no longer employed and reiterated its commitment to high standards and zero tolerance for misconduct. And lastly, a case of employment status. So the Court of Appeal is now reviewing a major employment rights case that could reshape hiring practices in aviation and beyond. At the centre is Ryanair pilot Jason Lutz, hired through the agency Storm Global, who was wrongfully classified as self-employed. 2 previous tribunals ruled that he was, in fact, a worker, entitling him to benefits like paid leave and pension contributions. Ryanair and Storm Global are appealing the rulings, but the British Airline Pilots Association is standing firm, supporting Lutz and other pilots in similar roles. If the Court of Appeal upholds the earlier decisions, it could lead to back pay and improved conditions for many agency-hired pilots, and could also force a broader industry rethink on gig-style employment models. Final ruling isn't expected for several months, but the outcome could be as game-changing as previous gig economy cases, including companies like Uber and Hermes. BALPA is calling on the companies to accept the rulings and work with the union toward fairer employment for pilots. So that concludes our weekly update. Short and sweet this week, not much going on. Employment law changes have already happened, nothing much going on with the Employment Rights Bill. And there's our top 3 employment tribunal cases. I hope you found it useful. I won't be seeing you next week because I'm actually on holiday. I'm going to a Eurocamp in Barcelona if anybody's interested. The first time I've ever been there, so we'll see how that goes. But I will be keeping you all up to date on my Patreon if you're following me over there. Take care everyone and I'll see you soon. Bye.